Let me just start by saying good morning and welcome. You might see me sneak out a little early. I got a meeting scheduled that's out of the office, so I might have to leave a little early to get to that one at 9. So apologize for sneaking out. But you are good hands with Randy, and Catherine Weeks going to be joining us. She's out making sure folks can get in, and she'll get you to the finish.
So it doesn't have anything to do with the topic that you're leaving. You
because Randy's right.
It's because I'm here.
I thought I had a meeting.
Okay, no, she goes, I've been listening to this for 15 years. You can't stand it anymore.
So have things changed significantly for you guys since the shooting here?
Yeah, I mean, yeah, it's they're locking things down. The back door's more secure, I can tell just by coming in. So they've done that. So we lock our doors during the day, and I think everybody upstairs has been doing that. So
what's the right way for us to come in? I kind of piggybacked, probably did something I wasn't supposed to do to get in.
Like tailgate coming in?
Yeah, yeah, exactly. So how do I not?
Typically, it should be the front door.
Okay, so just wait for somebody to show up at the window.
Yeah, I mean, at this time of the morning, I don't know if anybody's there. So
the main entrance to the door is the one that faces
the south entrance. The south entrance is for the general public and for members of the commission.
And then here, this door is our entrance to our office is always locked, and so checking with somebody at that window can let you in. Or
so that's what I should do.
Mm-hmm.
Maybe just call you.
Yeah, but this one it's fine. And then like we have Catherine out there to let people in.
Oh, okay.
Rochelle's an official part of her job is now loitering.
She's loitering by the door. Yeah,
that's great. I love it,
Michael.
But yeah, I mean, there were 4 or 5. I was just walking up to the building when everything started happening, so I ended up not even getting into the building at the time that it happened. I believe Becky was down here at the time, and there was a number of people in planning. There were 4 people upstairs at the time he got broke in and upstairs. So,
Well, being disconnected from Lawrence, I saw that story stir up about as much concern as any story that I've heard.
Yeah, it was.
People really reacted to this.
It was a unfortunate, random thing. So it was just, it's not anything that you could, try to plan for and protect, but things like this happen. So it was very unfortunate. But there's been a lot of assistance for the employee assistance program for those that were upstairs, because a couple of them were a little traumatized, as you would understand.
Yeah.
Understandable.
Yeah.
Oh, gosh.
All right. Morning, everybody in the room and online. Appreciate you making the time to come and join us for our midnight meeting.
Yes.
And
morning.
Before Randy gets started with the fun stuff, I thought I would start the meeting with kind of a look back and a look forward on applications that come through us. The look back, what we'll do in the future is, I'll let you know if it looks like things are changing or not proceeding as expected. So basically, things that you have saw at your last meeting in December, those are progressing, moving towards City Commission for their consideration of those items. So nothing really to report on items that you've seen previously. And then for our January Planning Commission meeting, we will be meeting on Wednesday, January 28th. So just one night this month, and it should be, the agenda is a short agenda. We had 3 items listed on our legal that was posted, but since that time, one of those items has been deferred. So we'll have 2 items on the agenda. We have a rezoning, and then we have a county CUP application. So
one city, one county.
Mm-hmm.
Okay.
Yeah. Cool.
Yeah.
February, maybe a little, I would anticipate we will have 2 meetings. We'll meet both days in February. In February, we'll be catching up on some of the applications and things. Okay. I'm going to give this back over to you. And I did email everybody the documents, but we can share our screen. Randy's gonna kind of run through them and we'll just share the screen.
Okay, which
No,
one do you want first?
I'm sorry.
It doesn't matter to me. We're gonna do KOMA first, sorry.
Okay. And then to share this, Becky.
Yeah.
Yep, there you go. And then it's gonna be that KOMA. There you go. Okay.
We didn't put together a PowerPoint because I think we were going to do this in December and there was not going to be access to
Right,
that.
we weren't sure what technical, I can scroll through this. You just kind of tell me
Yeah,
to
so it's no big
scroll.
deal. Yeah. And anyway, I don't know. I think was there some discussion of KOMA and stuff at December? So
Yeah,
Yeah, a little bit.
we went through it, but I think we wanted to, yeah, Jeff and Catherine did an
So,
amazing job,
I'm
but
sure they did.
we wanted
I'm
to
sure
bring
it's more
you back.
interesting than me.
Don't tell.
It's a hard show to follow, I'm sure. So
Yeah. So we want to bring you back your.
if I get going and you'd rather hear from Catherine, just let me know. All right. Okay. We'll just get in.
We had this version in December.
Yeah, that's the same one I'm
Oh, okay.
going over. I didn't do anything different to it. I will add something to it probably for the next time. I didn't get it added this time. I'm going to talk about it briefly. All right. Well, the Kansas Open Meetings Act was enacted in 1972, kind of came out of a lot of reform that came out of the 60s, governmental reform. And basically, it's the cornerstone, is described as the cornerstone of public access to local and state government. And really, its fundamental purpose is that the business of the public is conducted in public. So you don't have, like they had back in the days, a bunch of old guys in the back room smoking cigars, making decisions. So this is so that everybody has input and can and assist, and they know what's going on. Makes transparency is what they're going after. And the Kansas public policy is that representative government is dependent on an informed electorate, and they've codified that as part of the thing. So it is an express violation of the Open Meetings Act to move a meeting or to another place and time or order or do things like this to subvert the purpose of the Open Meetings Act. And to that end, the courts construe all the KOMA liberally and its exceptions to KOMA narrowly. So what you know is we always try to err on the side of caution when it comes to the Open Meetings Act. So the Open Meetings Act applies when there are two criteria met, and these have to exist. The governmental body has to be a covered entity, and two, there has to be a meeting. So we have a covered entity and a meeting. These are the two things that create a meeting that bring the KOMA into play. So
Uncovered entity, you mean that it'd be covered by this law?
right. And the covered entity is defined as all legislative and administrative bodies, state agencies, and political subdivisions of the state that receive state money, federal money. So that's the city, the county, they are covered entities, and subdivisions of those subdivisions, planning commission, most advisory boards to the city. So those are, it's easy, a covered entity. The big change in KOMA this year is they have now codified that subcommittees of subcommittees and subcommittees are covered by KOMA. So like when we had wind turbines, they would put together an ad hoc committee to study that, have hearings. Those are now subject to the Open Meetings Act. Before it wasn't clear, it was our opinion that you would be, as you know, otherwise, why wouldn't everybody just put together a subcommittee under the number and do their business that way, and they wouldn't have to comply with KOMA. So anyway, that was always our opinion, that subcommittees. I think maybe the county had a different opinion at some point in time, but now the Kansas legislature has answered that question for us. So if there's a subcommittee that's formally put together by the Planning Commission, it will be covered by KOMA.
So if I am
go ahead.
I don't,
Yeah.
No, you go ahead and I'll ask after you try to go.
so if I am a resident
Mhm.
that says, this subcommittee on wind met, can I go back and have that undone?
No, it's done. And any time for bringing any complaints or anything like that, it has passed. So and those laws don't apply retroactively. They apply prospectively. It was never clear before. So they have not clarified it. So those are all fine. That decision.
Randy, so what would we have done differently if this was in place when we had the wind?
I don't know. I think there was, first of all, it was a county issue.
Right,
So I wasn't really involved in it directly.
Gotcha.
So I kind of know. We were just holding meetings just like their planning commission meetings.
Just like I see.
Right. Put together agendas, notice.
Not in here, like
Right.
your
Meetings
video.
shouldn't be at people's homes. Meetings should
Right.
be accessible to the public.
Right.
Like, all the things that happen wouldn't happen.
Right. So that's going forward.
Things, but I
Many of the
understand
things.
your point.
Right. So going forward, the Open Meetings Act will apply to subcommittees. So that's been clarified by the legislature, and we know the answer now, and that's how it'll be. So, but anything that happened in the past on that is still okay. It wasn't theoretically a violation at that time, or specifically a violation. So cover density isn't a big deal, but that was the only major change in KOMA this past year. The big deal is meetings. So a meeting is basically three things to have a meeting. It has to be a gathering or assembly of any way, through telephones, through internet, in person, like we have a meeting today with some people online, and here this is a meeting by a majority of the membership of the Planning Commission, and the purpose of discussing the business affairs of the body of the agency. So the three things, like some type of gathering or assembly, however it's done, by a majority of the membership to discuss the business affairs of the body. So we'll go through each of those things. So any gathering, any type of interactive communication, any assembly, when you're in the physical presence of another, that's a meeting, or at least that meets the first prong of whether it's a meeting. Telephone calls, conference calls, chat rooms, those things like that. Video conferencing, Teams meetings, Zoom meetings, those are all applied. Emails between individual commissioners typically is not, but however, if it gets to the point where you're talking about something and somebody hits reply all, that can be a danger, could trigger that first prong. So be very wary of hitting reply all when it comes to business of the Planning Commission. And we're not talking there about, we're having the meeting, it's going to start half an hour late, or here's the order of the agenda. Those type of procedural things don't matter. But when you're talking about this project that might be appearing before the board or something of that nature. So just be wary of hitting reply all when something like that comes in, or you get a message about something.
And what about chain emails that are one at a time, but not?
That will, we'll get to that.
Would that be text messages too?
What's that?
Like, would that be text messages too? Like if you had a group
Yes,
text
a
message?
group text message is the same thing. Yes, any type of interactive communication. Yes, I just didn't use text. That is an example that would apply.
Randy, it used to be 4 people is a meeting. Does this, like, if Gary and I are having coffee, is that a meeting?
Mm-mm. It could vary, but it doesn't trigger the thing because you are in the presence of each other. So that's the first prong. But the second prong is it has to be a majority of the membership of the body.
Okay.
So 2 of you can get together, 3 of you can get together, and they define majority as the next whole number more than half.
Okay.
So there's 10 members of the Planning Commission.
Okay.
So half is 5. So it has to be 6. So theoretically, 5 of you could meet over coffee and talk about a rezoning that's coming up. But as soon as there's a 6 or one of those people that are at that meeting report what was said to a 6th person. So it's very, very dangerous. That could trigger it. So
because that's different. Because it used to be 4, right? Wasn't that?
no, it was always 6.
It was always 6.
6 for this board.
I see.
So
That's why we chose 4 just to be
under that.
under that number,
I see,
right?
okay.
For a lot of our boards, we do have 7 members.
Okay.
And for those boards, it is 4 members.
Okay.
But for the Planning Commission, which is 5 and 5, 10.
Gotcha.
So it's 6 for that. So again, it has to be some type of interactive communication or physical presence of each other of 6 to talk about the business of the body. Now, it doesn't have to be official. There doesn't have to be a vote. You don't have to be making any decisions. You just have to be talking about something that's coming up Or it could be something you just decided. Whatever the business affairs of the board is, which is, pretty obvious, rezoning matters, special use permits, conditional use permits, those types of things that you would be deciding that are coming before you or just recently in the past. That is the business of the board. So that's what would trigger it. If you talk about those things, you get together and talk about the Jayhawks win last night or something, that's all fine. And that's not anything. You can even talk about planning in general, just theories and ideas and how, you think it should be. And that's not a problem because that's just general things. You can attend conferences together. The question is just don't make any comments about, oh yeah, we have a project like that coming up in the future. Well, now you might have triggered it by talking about the business of the body.
Maybe I have a couple questions.
Yes.
The new clarification, so subcommittees or whatever, that would be a majority of that subcommittee, right? So it's like as each entity.
Yes, it is.
The majority of that entity.
Yes, absolutely.
Okay.
Yes. So, right. So it would trigger a different number. So say you had 5 in the body, then it would be 3. Two people could get together from that subcommittee and discuss the business of the subcommittee. But once there's 3, that would be a violation.
Okay.
Yes.
And then the conference and the stuff you were talking about. So if we were getting together and talking about theory of planning and all that kind of stuff, as long as it's not like literally a project or something we knew, I suppose if we were doing a legislative function like the land development code, we wouldn't get to anything we're going to vote on or anything. But otherwise, we could really get together and talk about like, the future of Lawrence.
You talk about the value of the infill, or how you rather like to see more density or things like that. They're just general matters. I mean, that will inform your participation in the board, and we're looking for those types of things. It doesn't prohibit you from reading books or learning about planning or do whatever. Just as long as you're not discussing things such that it could impact somebody's rights before they come to the board.
Thank you.
And where do text amendments fall in that?
Text amendments are a little different, but again, you don't want to. Text amendments are legislative, so they don't have the same due process implications that perhaps a rezoning or a special use permit or conditional use permit would have. However, the meeting KOMA still applies to that, even though it's legislative. The standards for legislative and quasi-judicial are slightly different in that due process attaches to quasi-judicial, because when you're sitting in a quasi-judicial capacity, basically you're looking at a particular property or applying the rules and the law to a particular right. So somebody has a right to perhaps pursue a rezoning or a conditional use permit. And when you're applying the laws to that person's rights or that person's property, then that's when you're sitting in a quasi-judicial capacity. That's when due process attaches. Now, if you're just doing a text amendment, you're basically changing the law that would apply to the entire, could be the whole county, could be just the city.
Right.
But that applies to everybody. So due process doesn't really apply to that situation. Basically, the key is you need to be getting into due process is fine, but you have to have notice. Person who is right is being affected has to have notice, and they have to have an opportunity to be heard. And the key for you guys is you have to have a neutral decision maker. So you got to have an open mind. You may have an opinion regarding a project, but you need to have an open mind and listen to the evidence and apply the rules of law to what you hear at the meeting. You can discard certain evidence. I don't believe that person or whatever. That's your decision. Those are the things that you do as a board member. But your decision has to be reasonable. That's the standard. Basically, your decision has to be reasonable. A reasonable person would have to look at it and say, based on that evidence, a reasonable person could make that decision. That's the standard. Now, when it gets to legislative, you have a lot more latitude is what I would say. The situation then at that point in time is whether you're acting arbitrary and capricious, and that is no person in their right mind would make that decision at that time, or you're doing it for some completely illegal reason, I hate to say money under the table or something of this nature. Those would violate that standard. So that's the difference between quasi judicial and legislative.
But for KOMA.
But for KOMA, they don't make any draw any distinction.
They're the same.
Right.
Same open.
The text amendment thing, it's not unusual for a text amendment to be talked about because of the way it affects one piece of property, even though it'll end up affecting.
Oh, yeah, right.
And so if you know that Joe Blow's property wants this text amendment, it seems to me that you're in the quasi judicial kind of evaluation.
There is some overlap, yes.
Yeah.
Because sometimes somebody wants, well, I can't do this for my particular property, so we need to change the whole code. But it's still, again, even though it's brought by that same person for their benefit of their property, it's still going to impact or have an effect on the entire community, or it should apply everywhere.
So when it's that kind of thing, I think.
It's kind of a
really careful.
blurry lines. We got to be careful. Yes, I agree.
Okay.
Okay, so that's interesting. So we're talking about, just to keep it straight in my head, we're talking about KORA and KOMA that apply the same to all of these kinds of things.
Right.
Then we're talking about our actual legal standard of review or whatever the standard.
Right.
And that would be the legislative has the arbitrary and capricious. Quasi judicial has the due process, and then text amendments technically are kind of a little bit of both.
They can be.
Depending on how they come before.
Right. For example, when you did the whole new code, well, that was basically completely legislative.
Right.
Certain people, but I mean, that's always the case with the legislation. Certain people lobby for certain things all the time regarding legislation and how it's going to impact their business or their life, whatever. But sometimes when it's a individual brings a request for a text amendment, it could have some quasi judicial overtones because it's going to affect their personal property. But a lot of these are started by the planning department will see something and say, you know what, we're just having an issue with this particular way this thing is working. So we need to bring a text amendment to clean this up. Well, that's probably mostly legislative at that point in time. And that's a lot of what the text amendments are. But we do occasionally get text amendment requests from members of the public, which is, fine. And at that point in time, as Jay points out, the lines get a little blurry.
Because we've been seeing a lot that in order for us, we make the decision, but then if we make, we have to make an amendment in order to evaluate the property or make a decision, kind of.
Sometimes.
Some of them, we've had several of those in the last 6 months or something. So those would be even closer towards the quasi judicial because they're actually coming kind of with a project.
But again, the legislative decision is going to impact everybody, even though it was brought by the individual person and on their property. It's still a legislative decision. They're still going to use that same standard, but then once you apply it to that property, then that's going to trigger the whole quasi judicial matter.
Is that a case, Randy, where they should be looking at the legislative item holistically before applying it?
Yeah, absolutely, yes. That would be a good way of looking at it. But again, when you're doing a text amendment, it's considered legislative, and just as long as you're not arbitrary, capricious, or completely outside the bounds of the law, it's not a problem. And of course, you're a recommending body, so you're going to make the recommendation, and then the city commission is ultimately going to be the body that's going to be held to task. To be honest with you, I've never seen.
I see.
The planning commission isn't going to get sued over a decision. I've seen people try that in the past, but it doesn't go anywhere because you're not really a legal entity. You are a subdivision or a department, not a department, but you're an advisory body to the city.
Gotcha.
And so this planning commission cannot sue in its own name and cannot be sued in its own name. So city commission is the ultimate decision maker for the city. And if there's going to be an issue regarding it, it's going to arise there. Now, that doesn't mean that there can be some mistake made here that echoes up there, but it's going to be the city commission's fault still, but it might come down here. And there have been times where members of the planning commission have been deposed and heard in land cases. So it's not unheard of.
If the planning commission didn't follow KORA or KOMA, somebody wouldn't sue the planning commission.
Oh,
The city?
you know, they would be against you guys individually, so.
Because it's not like a
Right.
suit against, but it's not
It
like.
wouldn't be a
it'd the
lawsuit,
government, The
right,
state or whomever.
Right.
Okay.
Yeah.
It's more of a fine-ish kind of.
right.
Okay.
So anyway, as Catherine mentioned, the serial meeting is something to be really wary of. This has happened back in the days, and there were a number of people that got into trouble with this 30 years ago once you first had AOL and chat rooms or whatever. Commissioner 1 would say, you know, I don't really like this project. What do you think, Commissioner 2? And he goes, yeah, I agree with you. And then they send that to Commissioner 3 on Commissioner 4, and they were making decisions for the body through these serial meetings. That is the same as just any type of meeting. So, you know, you may only be communicating with one other commissioner about a project. This is why you have to be careful about when you talk to each other. You're not forbidden from talking to each other, but if Commissioner A talks to Commissioner B, who talks to Commissioner C and D, and then D talks to E, and E talks to F, now you are 6 members who have had a chain of communications, and that's considered a serial meeting. It might be a violation of KOMA. So that's something to be aware of anyway. So that's it. So you have to have a covered entity, and there has to be a meeting, and a meeting occurs whenever there's any type of interactive communication or a gathering by a majority of the membership of the body to discuss the business of the body. So are there any questions regarding that? Yeah, it's fairly straightforward. If you ever have any questions regarding any of that, you can reach out to us, reach through the planning department. They're excellent help, and they'll probably contact me at some point.
I know they did a pretty good job without you at the.
I think so too. I mean, they may not even need me.
Catherine, do you want to go ahead and take over now?
Yeah, Catherine, you're on. Pitch hitter. I've been benched. So basically, other parts of KOMA, the meetings have to be properly noticed. That's basically the planning department takes care of that. If an agenda is prepared, you don't have to have an agenda, but if an agenda is prepared, it has to be made available to those who ask for it. You can also move things around on the agenda. That's within your discretion. It's not a good idea to just tack things on or bring things up at the last moment. We would probably intervene and say, no, we can't discuss that now. We want to have it properly noticed and put that on a future agenda or something like that. Meetings have to be in open places. They have to be, voting has to be done. There's no secret ballots that are permitted. You can't go into executive session and take votes. You've got to vote in front of the public. And you cannot prohibit the use of cameras or other recording devices. But you can, you know, that no one has the right to stand up right in front of the chair or something to hold a camera. You can make them go to a reasonable place to do that. But we have that happen all the time in city commission meetings where people will film it or take videotape or record what's going on. And we just make sure they're out of the way a little bit and don't impede anybody's access to the board.
There are times that we've had meetings that certainly overflowed.
Yeah.
Is there any restriction on how small the space can be?
Right. I mean, if it's a consistent problem, we should probably look into getting a bigger space. But yes, if you held it upstairs and there was no elevators, that might be a problem because, you know, people with disabilities or with mobility issues may not be able to attend. So there are things like that. So, you know, locked doors maybe on the building might be a problem that we allowed access, but and public could get in, and we allowed anybody who wanted to come here today to do that. But those are issues that we have to take into consideration.
Study sessions, like what we're having right now.
Yeah, they're open. This is a meeting. This is everything. Yeah.
So we've got a Zoom call going, but it's not, link hasn't been put out there for the public, or?
That's, if someone would request it, would have requested it, because this was publicly noticed meeting, and if someone would have requested it and they wanted to participate, or they don't have the right to participate, but if they wanted to watch it, right, then they could.
So, sorry, go ahead.
Will this recording, are we recording this? Is this going to be posted?
I do not know. I doubt
No,
that
we
it
don't.
would be, yeah.
And I guess where I'm trying to go with that is there seems to be a different level of, I don't know, just how far we go with making this particular kind of meeting a public meeting is different from like our meeting where we would actually take a vote on something.
Right. Yeah,
I'm thinking about past work we've done and how historically subcommittees were allowed to operate. The difference between those and now we're saying, okay, all those need to be formally noticed. They need to be available to the public. It's all good and fine. Never had any objection to that. But how we actually treat those meetings and I'm just wandering around here mentally, I'm sorry, but I'm trying to tie that back to what it might look like as work groups get together in the future, how projects, tasks might be taken on, and try to avoid a situation where, because we put a little more rigor around the language on sub notification, what prevents a group from just informally becoming a 4-person coffee clutch and going about the work that used to be done. And now instead of actually making it more transparent, it actually becomes less transparent.
Yeah, the public can come and watch, but no one has the absolute right to make a public comment.
Yeah.
I mean,
but with this
for
change,
this meeting,
with this change with tightening up KOMA, I can freely join a group of 5 commissioners together, and we can get together and talk about anything we want to talk about.
correct.
Not noticed.
Right.
But to do anything formally,
Correct.
now that needs to be a completely different thing. My sense is that we've created an environment by trying to make this a little bit tighter that might actually drive behaviors that are different than that.
It might very well do it. I mean, there's always, when the legislature passes a law, they have an intent, but there's always sometimes opposite reaction, and there's always an action and a reaction. Unintended consequences. A lot of times I'll draft an ordinance or something and that's a really good idea. And all of a sudden it's like, oh, we didn't really count on that. And we have to come back and change it because it has an unintended consequence. And that happens
But in that
in the
case,
legislature and with the city.
I would think if your 5 people met more than once to talk about it, then you're creating a subcommittee. But if you have 5
Subcommittee is something that's formally done.
Right.
but I mean, inadvertently,
That's kind of my point. You're legally allowed to do this thing. And there's no restriction or prohibition in doing that can have an outcome on what happens, and decisions that are made downstream. That before could have been a part of a formally assigned, formally structured group.
Actually, not that much has changed, even that, I mean, historically, like what they did is they codified the language of the intent that most people were following, and that they actually intended, that AG has some opinions out there about how we were supposed to kind of be interpreting this, and they've codified that to say, yes, definitely for sure, these sub-entities need to apply with KOMA because they are formal subcommittees of governmental groups. But really all the thing you're talking about, I agree with. I see what you're saying. What you're saying is it could happen even before the codification of the intent of what the legislature had done. Because basically it's like, yeah, still less than a majority can get together and talk anytime they want. But they've been able to do that before this or after that. And so to the extent codifying this, right, and encourages people to do that, that's more of a concern about
Yeah.
the same concern has always been there about how are people operating and are they operating within the actual law, I guess. And it's not illegal to get together for 5 people to do it. So
Correct.
now when those 5 people get together though with one more person and start to have this discussion, all of a sudden they've created a serial meeting. So then I think your concern would be, well, if they're meeting regularly as a group of 5, have they talked to anyone else? And maybe even to the next step, when they come to the meeting to talk, right, there's ex parte disclosures that they would need to be making if it's a quasi judicial situation. And I don't know about legislative situations.
No,
And so
we do them, but they're not required. because
yeah.
it's
And would
due
that be a
process.
serial meeting? If 5 people are meeting all the time, talking about something, and then they come to the meeting to talk with the broader group, all of a sudden now they've introduced additional people. How would that work?
Doing in the public is fine, and there's not ex parte communications among yourselves. That's not ex parte communications. And the communications with staff or communications with me are also not ex parte communications. Those do not need to be disclosed,
So we can get together and talk about.
right, without reporting back that what you had talked about. Now, you can, once you talk about what perhaps was talked about, you're in a public place, in a public hearing, and then all of a sudden it becomes public, and it's not that kind of washes away.
Getting together and meeting, whether it's legal or not, is exactly what the public hates.
Right.
I mean, it is.
That's
there's
what
the spirit of the law.
That's what the spirit
Yeah.
of this is.
Yeah, and
Yeah.
Yeah. No.
It is exactly what they hate, and I can't do anything about anybody else what they do. But I said in another meeting, I don't call and talk to you guys and say, what are we going to do? What do you think about? I'm going to hear what I'm going to hear in the meeting. But the public that says stuff to me does not believe that's going on. They do not believe that's what, oh, you've already talked, you've done,
I know,
made these little. But I can only do what I can do.
Yes. And one other distinction about a formal subcommittee versus a non-sub, usually if there is a formal subcommittee established, they've been given a task. They're going to report back. They're going to make a recommendation on something. They're going to study an issue and report back, something of that nature. Typically, if 3 or 4 get together informally to discuss the agenda for the next meeting or something, that's a little totally different thing. They're doing that personally, not as a body to report back to the full body.
Well, maybe everybody else knew this, and I was just the dummy. I do not feel good about even though it's legal, about the 4 of us that got together and met, even though at the time I thought, well, I guess this is just the way things go. But I'm not sure what the outcome would have been and how much I would have gained had it been public, what we were talking about. And so I have some uncomfortable feelings about my part in that with the wind regulations themselves, that my eyes have been opened to my part in that, even though it was legal.
I believe the county council, that was their recommendation or the opinion of the county councilor at the time. And I think you guys followed what they had recommended. Jane, you had a question?
I do have a question. When we post an agenda, do we have to include any written materials that support what the agenda is, whether it's KOMA or KORA, or whether it's a staff report on an item?
We do not. We just have to post the agenda, and we typically do send out or make the packet available for people so that just for transparency purposes. But for when you do an agenda, first of all, you don't even have to do an agenda. If you do one, you have to make it public, and the agenda could be just simply, we're going to talk about this rezoning, we're going to do this, and it could be just a list of 3 things, but we don't have to do all those things. But we try to go a little further so that people understand what's happening, make the staff reports available. I think they try to make communications available, things like that. So we go a little bit further.
I apologize. I have to step out.
That's right.
Thank you, Becky.
Thank you, Becky.
So if we have that, can we have like a formal agenda, like it can be just business, new business, and then things that come up. I'm thinking of a different entity, but I'm just, so if I have an agenda, I can have like, this is our agenda. This is like the agenda we follow every month or whatever, and have it posted. This is the agenda. And then things will come up, and obviously the agenda will be filled in, not written, but like old business, things will be brought up under old business that aren't necessarily on the agenda. And that's fine if we kind of always follow the same old business, new business, this.
Right.
And then that can just be like, this is the agenda of the group. It's posted, it's available.
But the additional element to that is we also have a requirement of notice, and that notice posts when that item is going to be published, or heard. So that's one reason also why it ends up on the agenda, is because it's linking to that notice that we're also required to.
And that would be a part of the quasi judicial, right?
Right.
Looking for
And we're actually by ordinance required to give post notice. That's why we have certain deadlines. You don't get it in by a certain time. Ordinance requires us to post.
So if there's not an item on there that requires individual notice, then you could have like notice of the meeting and the notice of like your general agenda that goes with that meeting. And if there's not any item that has to have additional notice itself for the item, you could just kind of do that on a basis that everybody would kind of know when the meetings are, what the agenda is.
Yeah.
But if otherwise, it's also okay to not post the agenda publicly, but to have copies available if people show up.
Correct. That would work as well. If somebody wants a copy of the agenda and you have one, you're obligated under KOMA to give it to them.
Okay, but not distributed.
You don't have to distribute to them, but I mean, what we do, I think we have a listserv or something. People request the agenda all the time, and we just put them on an email thing, and it's shot out both for Planning Commission, for City Commission. I think Parks and Rec Board. I think that most of the boards do it that way.
I'm on a little lower budgeted things, trying to figure out to make sure I'm following everything right. Thank you.
Question.
Sure.
So in regards to noticing, what are, I guess, two-part questions. What are the specific requirements of noticing? Like, where does it have to go? And two, as we move forward in our society from a communication technology information age, and things like newspapers are disappearing left and right, how is that going to change?
Notice you're.
So notice it is located in, I think, 16 of the Land Development Code. It tells you which types of applications require specific notice procedures and where that notice has to be posted. So it is all in the Land Development Code. And currently the newspaper is still an element that has to be covered as far as notice goes.
Correct.
Yeah.
And so the second part of that question is, at some point in time, if newspapers do disappear, a lot of, we're required to publish our ordinances to make them valid. The legislature is going to have to deal with those issues at some point in time and figure out what else we can do or what would suffice. I mean, they've relaxed those rules a little bit. We used to have to publish the entire ordinance. Now we can do summaries and some things like that. So we'll see what happens in the future.
Yeah. And just because I know that things like the Journal World used to be, I'm sure, tens of thousands of printed copies a day.
Yeah.
Now it's thousands. I know the Kansas City Star used to be 300,000 a day. They're down to 18,000 a day now. So, I mean, the printed version of papers, it's plain flat going away.
Right. No, I know. And that's something that the legislature is going to have to tackle at some point in time. Yes.
I was curious, is there any conversation around also it being behind a paywall? Like, obviously you used to have to take the paper, so you were paying for the paper anyway, but now we have so many, we have the Lawrence Times, which is a free paper with no paywall, and then there's the Journal World, which has a paywall. Right. And so obviously we have to follow what's been in our statutes for a long time, but is there any conversation around the paywall issue or anything?
If there is, I do not know.
The legislature or anything?
I'm not aware of it.
Because that's in addition to that, we've also got
you used to have to pay the subscription, and the kid would toss the paper onto your driveway or whatever in the morning. They still do that actually, but
In the
I just didn't
evening.
know.
in the evening, yes.
Yeah.
When I was a kid, we got them in the morning and in the evening in Kansas City. There was the Kansas City Times and the Kansas City Star. So yeah, it is a different world, and that's something that they're going to have to deal with. But currently, since there are still our newspapers, our obligations is to publish in the newspaper as the official newspaper of the city.
Charlie, would you end the cinnamon rolls?
Since you brought them, I would say you
All
are.
right, so what happens if there is a violation of KOMA? Someone makes a serial meeting and somehow the 5 people get together as Commissioner Rexroad talked about, and then they brought a 6th person in and there's a violation. What happens? Well, any person who's aggrieved by that would be maybe some applicant who didn't get what they wanted, or maybe neighbors who neighbor got what they wanted and the neighborhood didn't want. They can bring an action in district court. That would be against you individually. The district attorney probably against the city as well. It would actually involve the city. And the district attorney and the attorney general are also empowered under the act to bring actions against you for violations. Remedies that can be obtained in district court are injunction. They can enjoin the action of the board. They can do a mandamus order, which is basically a direction that you follow the law. The law is this and you do this. There's civil penalties that attach, and the payments of costs would go against the loser of those types of cases. But there are no damages that would be covered. If an action is brought, be aware that this is important to the state and it will be heard early. They will set things aside in a district court to hear this early. So they get to these very quickly. The other thing that to be aware of is that the burden of proof is switched. The burden will be on us to show that there is no violation, which oftentimes showing a negative is not easy. So we would have to show, we didn't violate it. So that would kick in. So also any action that's taken by the board could be voidable, which basically it could be just wiped away. Civil penalty is up to $500 for each violation, may be assessed against each of you individually and against the city as well.
Is that per day?
Per violation, not per day, per violation. If it happened multiple times, it might be 500 times per time that it happened. And it doesn't have, you don't have to have a specific intent to violate the statute. A lot of times you have to have a specific intent to violate the law before you can be prosecuted or be liable. Here, it just have to be a knowing. So if you go into the communication knowing what you're talking about or knowing that you're talking to another commissioner, that's probably enough to show culpability. And then also an injunction can be issued against us. But basically, really what's going to happen to you is you will get an embarrassing thing in the newspaper to the extent they exist or online. You'll be on the Lawrence Times and you will have to go to class. That's typically what happens, but that's no fun. So anyway, that's
the basis of a movie. Like I think I saw that movie. Everybody's in class.
You have to go to class.
Yeah. So you said cost, right?
Yes.
So what would that be, like legal cost?
Yeah, it would be the basically it's the cost of filing of the fee, and if there's any other costs that are allowed under the state statute, sometimes if there's depositions, sometimes the discovery costs can be assessed to the loser.
It could be a lot of money.
Could be a couple $1,000s for that. Yeah, it could be 5 figures perhaps. Who knows how long the lawsuit goes or how much discovery needs to be done. Costs typically aren't that high though. I mean,
What about attorney's fees?
Typically attorney's fees are not recoverable in these types of cases.
Darn.
Yeah, I know. That would add another.
About executive session? Have we talked, are you going to talk about that later?
No, I'm not. If you have a question about it, this would be a good time. We don't do executive sessions for advisory boards, or we advise against it. The only one that actually does have a provision that allows for executive session is the community, whatever they're called, Community Police Review Board at this point in time, because they will hear complaints against a particular police officer. And to keep those personnel issues private, they will recess into executive session to review evidence, and they still have to make their decision in public, or they will make the review of the evidence in executive session. But there's no need for you guys to have executive session that I can think of. But if one didn't have to come up, then there have to be a motion. We'd have to fit in with one of the categories that allow it, like probably it'd be attorney-client privilege or something like that. But since you're not even amenable to suit, that probably wouldn't even be triggered. There would be no personnel issues. You don't have any employees. So it'd be very difficult to fall within one of those things. And not only you have to meet one of those, then you have to have a justification for going into it. And that'd be to keep something confidential. And really, there's nothing that Planning Commission should be keeping confidential that I'm aware of. So.
But the only reason I'm asking is because like I watched too many commission meetings, I think. But like people will be like, oh, you have to say, the board has to like say what they're going into executive and so I'm just curious a little bit about that, because I've heard people complaining about that or in public comment, not for the Planning Commission, but I was just a little curious, like what is that like? What do you say? And then can you take a vote in executive? If
No,
you're saying you can never vote. So
no.
if it's like an employment matter or whatever, and
It's a personnel matter.
you can't
No.
vote on so you have to do the actual vote for whether or not you're going to fire the
If
person
there's
or
a
whatever.
vote, right, if you have to fire them. And that has happened with the city manager 20 years ago, probably, yeah.
Oh.
They went into executive session and discussed the personnel matter and came out and directed
Okay. So no voting in executive session. You have to
Right.
say what you're going to do. No voting in it. You just discuss. Then you come out of it. And
Right, you don't.
then if a vote's required, you take a vote.
So, whatever the problem was or the issue was, they kept that confidential because it was a personnel matter, but then they took the action against that person in public. They didn't say the reasons, but they said,
Time to move on.
time to move on.
Okay. Okay. Cool.
Right.
And I just wondering, because then I heard people saying that you need to say what it is you're
Right. You
going
have
into.
you have to state the reason. There's 6, 7, 8 reasons that are listed in the statute. The ones that we apply to us most of the time is attorney-client, personnel matters. If the city's seeking to purchase or sell property, we are allowed to go in to discuss it. So, because if you discuss it in public, guess what happens? The price of the property goes right through the roof. So there's certain things that we're allowed to go in and discuss in executive session.
It is question about that, and I'm only bringing this up, having been on the school board and dealt with KOMA for a decade there. Based on what happened at City Hall 2 weeks ago,
Right.
talking about matters of security,
Right. That
is
is
a reason. Is it? I mean, in theory, impossible if we wanted to change the secureness of our meetings for whatever reason. We could. That's about the only reason. Yeah.
That would be a reason to go in. And in fact, we had one this last meeting. We had a 15-minute discussion to talk about security measures, that if we had discussed those security measures out in public, obviously, then everybody would know what those security measures are. So that is one of the reasons that you can go into executive session. And we've done that 3 times. We've had meetings to talk about what would happen because we, concealed carry and various different things that are allowed. If there was an active shooter situation at public meeting, we have discussed those in executive session.
You have concealed carry in governmental buildings?
Yes, we can't ban them.
I thought there was also a thing that said you could stop it.
We can say we recommend, but we can't stop it now.
Okay.
Because we'd have to have metal detectors and somebody there all the time to allow you to walk in, and so that you can ensure that nobody comes in.
Yeah.
And whether that will happen now, I don't know, but in the past, the costs of that have been prohibitive for city commissions to do that. So yes, there could be people carrying in the building.
So we should probably have a session talking about what do we do?
Well, yeah, if you wanted to do that, we could set up mid-month. It might be good and have the chief of police come talk about that, because that's
Wouldn't be a bad idea.
I think it would be a good idea.
We only have 5 minutes left
Yes, we have
today.
5 minutes today.
And I don't know if we're through with KOMA, but
We are.
could you give us 5 minutes of KORA?
Oh, well, KORA really doesn't apply to you so much. The thing that you have to be wary of is the KORA, the changes that have made over the last 5 or 6 years, is that if you have information stored on like a city issued thing, that is recoverable. I don't know if you have, I don't think you do. City commissioners do. They get phones and they have computers that if they, once they use those are all recoverable under Open Records Act. Private phones, private computers, information you have stored on your own private things are not subject to KORA. We would not be coming to your house to confiscate your computer or your cell phone.
The business of the government on my own personal computer and not.
No, I mean, yeah, that's what got some people in trouble, but yes, you can. I would recommend not doing that.
Emails could be subpoenaed.
What's that?
Our emails could be subpoenaed. Like
Theoretically, yeah. And then, if you get a subpoena and, we would probably object, but just to protect everything. But the court could say, yeah, in a lawsuit, it might be relevant, right? And it might be discoverable. It's not probably discoverable through KORA. We would object and, they'd have to sue us and the court would have to determine that, that is recoverable under the Open Records Act, and we would do it. The Open Records Act for the city basically goes through the city clerk's office currently. We get to see a lot of it, and we get a lot of questions regarding KORA from the city clerk. But I haven't seen one that involved the planning commission in a long time.
I was asked a year or so ago to reveal any text or email communication between a set of names, and
that could very well be regarding that was a lawsuit involving the wind turbines. Was it the wind turbines? Yeah, I think so.
I didn't have anything.
No, the solar panels. It had to do with solar. Yeah, there's a lawsuit involving the county.
Nothing about any of the things being asked, but they didn't differentiate between personal.
No, they didn't, because there was a lawsuit that was brought, and they were looking for communications, and we were impacted tangentially because we had all the employees are here, so they went through the employees' emails regarding any communications with this person, this company, and those things like that. And those were all discoverable and not found to be relevant in that lawsuit, but it had to do with solar.
Did you have to turn it over, Gary, or was it just?
I had nothing.
You have, I see. If you had something, you would have had to.
Sure.
So if we are aware of a lawsuit or think a lawsuit's coming, we should immediately delete everything on our devices.
You
right?
didn't hear me say anything like this.
No, I thought it was
I would not advise to do that, but if it happens.
Hey, this is changing the subject from James.
I will say this too, it does behoove you to be careful who you're responding to via email.
Right.
Even with a project that I had, a homeowners association accidentally included me on their email list. So everything they were discussing was coming through, and I immediately responded, please remove me from this list. My emails are subject to open records request. I'm not sure you would want your HOA business in an open record.
Right, absolutely. We get, we get that every once in a while. It's like, well, don't give us this, because as soon as you give that to us, it's an open record.
Yeah.
So, especially if it's proprietary information.
We get emails from citizens.
Right.
And so if we respond to that email, that could be used by
theoretically
residents. Hey,
right,
I mean,
we want all, say there's a lawsuit regarding rezoning that happens from time, and is there any communications between? We want to make sure that there is no impropriety and no untoward or unbiased and no exchange of goods for the decision. So we want to see all communications.
Because we want to communicate, but right. it sounds like. What would your advice be? My
advice would be always is be very wary of communicating with the public, but I know that's just not possible.
Right.
I mean, it's going to happen. People are going to talk to you about things they have interest, and as
seems like the opposite advice that we should be taking is trying to serve that very public.
Well, I get that. That's what you are, serving the public. But as an attorney, sometimes if there's no communication,
exactly,
there's no issue. Right. But is that in a perfect world, that would be the way it is. But I know it's not going to happen that way, and I'm not going to say don't do it. But it happens.
Well, maybe we should store it up and then say at our meeting, well, when Susie Q said this is my response. And when Joe said that, this is my response.
Yeah, you could very well do that. That's kind of what ex parte communications are a little bit about. You want to know what the communication was and what you learned so that everybody has the same information to make the decision. That's due process.
Make the meeting.
It has been brought up
It would.
by a couple of people that I can think of, the minutes of our meeting. This is off the subject.
Right, but we have that.
Then we just go, the vote was X to X, but we don't have, it was 9-0 or.
I believe those meetings are recorded. Yeah, so
Yeah.
that's why it used to be somebody would be sitting there and typing and take it and say, this member of the public had this to say and this member of the public had that to say. That was sometimes minutes would not appear for 3 or 4, 5, 6 months down the road because it was so time consuming.
So because it's recorded.
Because it's recorded, we just go to the action minutes and we're not required to do anything more than that.
Thank you very much, Randy.
So we didn't get to a really important area, that's conflicts of interest.
Yeah, that wasn't on our
How are we gonna
agenda.
deal with that?
That wasn't on our agenda.
We just didn't get there, but I will say if you have a substantial interest, which are listed in the statute and they're in list, there's 6 things. File a statement of substantial interest with the county election board, the county election officer down at the courthouse. If you have a substantial interest, and there's 6 things that are listed that show
What are
you have
those 6 things?
like if you got $5,000 from, or you own 5%, and if you own $5,000 or 5% of a company, you have a substantial interest in that company. If you receive $2,000 of taxable income from somebody, you have a substantial interest. If you serve on the board other than some type of nonprofits, you have a substantial interest. If you have received a commission greater than $2,000 or a spouse has received a commission, if you are a real estate agent or a stockbroker and you receive $2,000 for a transaction from somebody as a commission, you have a substantial interest in that. If you receive a gift of $500 or more from any individual or any business, if you win some type of sweepstakes at a grocery store or a shopping spree or something like that, you have a substantial interest in them. Those need to be reported to the county election office, or you need to recuse yourself.
Because we live all over the county and we live in the areas where these items are coming up.
Right.
How do we differentiate when something might be something that we're as part of our family and the family has an area there, or like me, I'm living.
I don't mean to cut this off, but it wasn't posted on our agenda, conflict of interest.
When are we going to be able to talk about this?
But I think it's a good topic.
When can we talk about it?
How about at a mid-month?
Can we pick one? I'm serious now. Can we pick a date right now?
We have a long list and Becky wants to put the
That
list.
sounds like we'll get to it when we get to it. And I'm asking as a commissioner to
I
have
think
this
it's a good
specific
question.
conversation.
Yes, I think it's very important that we do
Yeah.
that. And I was deferring to the staff because they wanted to have an order to our mid-months, but I think that. at least
I was understanding I was doing both, but that's fine.
Well, we've never not done.
Yeah, and it's fine. And the thing to be worried about is just if you have an issue, you can let us know. And if you're not comfortable, there's a ethics commission in the state that they'll give you a free opinion and stuff like that.
Randy, would you be available for the
Yes.
mid-month in February? Which the date, I
Yes,
believe,
if
would
it's like the 15th or 14th, somewhere in that range, I'll be,
I'd be in the middle on a Wednesday.
I would be available.
Can I suggest that we also talk about ex parte communication at that same thing? Because I've had several
Okay,
people
yes, we can do
complain
that.
about the way we do it, members of the public, and I just would like clarity on.
Yes.
I think that would be great, and I
Okay.
think it needs to be something where we have noticed it, so.
All
people
right,
can
very good. We will do that. I will be available in the middle of February.
Thank you very much.
That's all right. Thank you, guys. Thank you for the donuts, and everybody have a great day, and
Yeah, yeah.
thanks for all you do. Yes. See you guys online.